And welcome to Richard French Live. I'm Dominic Carter in tonight for Richard. Sheldon Silver's trial is winding down and Dean Skelos' is heating up. Prosecutors at the Skelos trial are focusing on wiretap phone conversations that they say are incriminating. And the jury has been deliberating for most of the day in Sheldon Silver's trial, but already there is a holdout juror.
Thank you, Mr. Speaker. Thank you.
Sheldon Silver is charged with honest services fraud, extortion, and money laundering. But tonight, there may already be trouble with the jury. The first two notes to the judge, right after lunch and less than 2 hours of deliberating, focused on what happens if you're feeling pressured by another juror. A second note asked the judge if there's a code of conduct for New York State legislators. It is the jury instructions from Judge Caproni that could decide whether Silver walks or is convicted. Quoting Judge Caproni from her charge to the jury, the government has to prove that Sheldon Silver received bribes or kickbacks as part of a scheme to defraud. Adding that, and this is key, the government does not have to prove that both parties knew this was bribery, only that it was Silver's intent. A clear reference to the first prosecution witness, Dr. Jonathan Taub. The intent of the giver may be different from the intent of the recipient, the judge said. Dr. Taub is identified in the criminal complaint simply as Dr. Number One, and he testified he was unaware of any financial gain for Silver with the law firm Whites and Luxembourg after he referred cancer patients to Silver. In the closing arguments yesterday, the prosecutor charged, quote, "What you have heard during this trial is what Sheldon Silver secretly has been doing for years, cheating, lying, and getting away with it." The defense countered. Sheldon Silver did not sell his office. There was no quid pro quo. He is not guilty. Meanwhile, in the Skelos case, at the heart of the matter, prosecutors say Dean Skelos strong-armed companies with businesses before the state into giving work to his son Adam. This was a secretly recorded call played in court yesterday with the head of an association of Greek diner owners who was apparently unresponsive to a sales pitch. Prosecutors say Adam Skelos was hostile and demeaning.
A lot of people don't have my cell phone number, okay? I don't give my cell phone number out to everybody. You have my cell phone number. Now, I'm getting missed calls and this and that. It's a privilege to have that number. Now, if you want to utilize my reach and business opportunity, then you call me and I'll set up a meeting. Otherwise, don't tell me you're going to set up a meeting and not set it up, okay? Because you're like, oh, we do very good things, we do it, but you don't do a thing, okay? That's why you are where you are, and I am where I am.
In the call, Adam Skelos also seems to suggest he can perform political favors, but when asked what, he says he won't say on the phone. Bill Waugh is a defense attorney and a former assistant U.S. attorney. Counselor, so nice to see you tonight.
Thank you.
Lots to talk about. Let's get right to it. This trial is in disarray. I left the courtroom just a short time ago, and for a juror, clearly a holdout juror, to release this, to give this letter to the judge in which she is saying, I want to go back over this again because it's very important, that she asked to be excused as 2 hours into deliberations. What does all of this mean?
Well, I've been practicing and trying cases for almost 50 years, and I cannot remember any instance in which within 2 hours of the beginning of jury deliberations, a juror sends out a note asking to be excused because she's being pressured by her fellow jurors. They're not listening to her. She gets headaches. She's uncomfortable. She feels stressed out. That's usually the kind of a note that is generated after the jury's been deliberating for a substantial period of time, over days, maybe over weeks, and the tensions build up. But in this case here, for it to happen so quickly, it suggests to me that there's a real problem here. And although the judge has retained her so far.
Define problem. in this case?
Well, a problem in the sense that if this juror remains on the jury and holds fast to her opinions, and the other jurors aren't able to reason with her and persuade her that they're correct and she's not, you're going to have a hung jury. That's what you're going to have. You're not gonna, the jury verdict, whatever it is, has to be unanimous. If she is in disagreement with her other 11 jurors and she sticks to her guns and they stick to their guns, there is no way that this case can reach a unanimous verdict.
You're the expert. I'm not. You're the former federal prosecutor. I'm not. But I've covered a lot of these trials. And what this sounds like, I mean, let's not forget, okay, there's the backdrop of politicians are not seen very well these days. But we are less than 48 hours away from Thanksgiving. Everybody wants to be home. I have watched this jury. I am telling you, counselor, some of them have been bored to death. Some of them have not been able to follow the political process. Some of them have not been able to follow the legal process. Imagine sitting in that courtroom, as you well know, from 9:30 in the morning until lunch, and then when you come back at 2 o'clock, you're there under Judge Caproni. You're there until 5:30 every day, including on Fridays. So the bottom line here, what it sounds like is that with Thanksgiving coming around the corner, these folks want to go home. So it sounds like that they were going to vote to convict right out the gate, and this juror is a holdout.
Well, in the first place, the judge had already told the jury that they weren't going to be sitting on Thanksgiving. They would be coming back on Monday.
Right? Correct.
So the jury knows that. But you touched upon it a minute or two ago. Looking at it from my perspective, the climate is such that I have serious questions as to whether any public figure can get a fair trial when he's indicted or she's indicted and charged with these crimes. And the reason is because the public doesn't have any confidence in the integrity or honesty of the elected officials. They suspect the worst. They expect the worst. So basically, when you see jurors falling asleep so early in the trial, when you see them not paying attention or appearing not to pay attention, that tells me that these jurors have already made up their minds. They don't have to hear any more evidence. It's like anything else. You know, boredom sets in when you've already heard all you have to hear and you don't really want to hear anymore. So I agree with you. I think that if I had to make an educated guess, given where we are right now, I can more easily conceive that there would be 11 jurors who are convinced that they want to vote guilt, and I can seeing 11 jurors who, after listening to this trial and all the testimony, you know, they believe that Mr. Silver is innocent.
Okay, so counselor, so walk me through this hypothetical scenario that it may not be much of a hypothetical, but okay, so if I'm Sheldon Silver tonight, I'm on my knees being thankful because this holdout juror, she has already set up my appeal. I mean, if he is convicted ultimately, can he make the argument on appeal that we had a juror that believed in my innocence and that she was removed from the jury?
Well, you're walking a tightrope. I'll tell you why. Because basically, in order for there to be an appellate issue, his lawyers, his defense team, has to vigorously object to the dismissal or excusal of this juror.
And these are well-paid lawyers, so we can make the assumption that they will vigorously object.
Well, I think so far they've already indicated they don't want her dismissed or excused.
They have indicated they don't want her dismissed.
But the difference is that this is a situation where the juror herself is asking to be excused because of stress, mental pressure, the inability to basically reason with the jurors. So there's going to come a point where the judge, after he gave a curative instruction today, after she did, which she told the jurors, look, you have to respect these others' opinions. You got to talk to each other, reason with each other. If this goes on over a period of days and this juror keeps renewing her request to be excused, claiming that she can't think, she can't reason, she's stressed out, she's getting headaches, she's getting sick, then there comes a point where, despite what the defense may say in objecting to the dismissal of this juror, the judge is going to make a determination that the juror must be dismissed, the juror is asking to be dismissed, and that's the only way that this jury can continue to deliberate. In that case, there is an appellate issue, but if the reason that the juror is being dismissed is because the juror is saying she cannot deliberate because she's getting sick over it, the appellate issue loses its ability to be persuasive.
It is now time for a break. Up next, it's not just Skelos and Silver on trial. We'll look at how the entire culture in Albany is also being scrutinized.